Our next presenter is Bryson Eubanks, who has recently partnered with Drew Clements to form the firm of Clements and Eubanks. He is an attorney where in that firm, he draws on years of personal and professional experience to assist clients with elder law, Medicaid planning, veterans benefits planning, estate planning, and probate matters. Bryson previously served as a public benefits specialist at at the elder law practice of now Johnson McGinnis, Takis McGinnis, where he learned how the law could help him make a difference. He also served as public benefit specialist at Elder Law of Nashville, where he was a very valued member, where he focused on Medicaid and veterans benefits planning. He holds degrees from Carson Newman University, Appalachian State University, and the Nashville School of Law. How do we get our clients on Medicaid, Bryson?
All right. Thank you, Barbara. Let's see here. All right. So thank you everyone for having me today. I feel like one of the jobs that I had in this process was to take and compartmentalize and put back together a lot of the good things that we heard Barbara talk about, and John and Pam, and then add to it some maybe real life things in regards to this is how this works. Because one of the things with TennCare is, and especially getting our clients on TennCare, is until you actually get into the process of it and actually do it a couple times, you can read things in the book all you want to. You can look at the manual, et cetera. But until you do a couple, or until you hear somebody talk about, here's some situations that this is how this works, this is how the rule applies, it's really tough to know what's going on there. So some important considerations when this happens are as follows. Is one, just like John touched on in regards to the estate recovery, TennCare is a rules-based program. I've heard people say before, it's like with estate recovery, if you don't meet the rules for estate recovery, it's not going to happen. If for some reason it does fall under that, then estate recovery could apply. Same thing with qualifying for TennCare and the things that you do to undertake that qualification. It's not for rich people. It's not for poor people. It's for people that qualify. We're going to touch again real quick on that three-prong, what I call TennCare test, and why it is most important. We're going to talk about applications and how you actually file those for your client. A lot of the standard verifications that one would need to provide, as opposed to potentially the kitchen sink that sometimes come in those letters to you from TennCare. And then just some spin down planning options. And I'm going to sprinkle in some things of, hey, this is a case that I have going on right now. This is how this works. But I've also got a case study at the end. And I have another presentation like this where I had 2 or 3 case studies. But I kind of took those out, and I think this is going to be good. And I'll use that case study at the end. That also includes a resource assessment for spousal case, and what I use called an overview. So again, there's the three-prong TennCare test that I think we all know about, that again Pam touched on with the medical, which is the pre-admission evaluation, the income test, and the assets test. So again, just to reiterate, these things, when TennCare looks at them, from your ability, your client's ability to transfer, be mobile, feed themselves, take their medications, do they know who they are, where they are, when they are, et cetera. It's the most important part of this. It doesn't matter what you do from an income standpoint. It doesn't matter what you do from an asset standpoint, which is one of the things I think we want you all to walk away with today. That if they don't pass this medical part, you can do all the planning in the world and it's never, ever, ever going to matter. So one of the things that I do when I initially meet with my clients is I always go through these things to see, okay, where do I think that they are, if they don't already come into the office with notice that the nursing facility or through home and community-based services they've completed a PAE. That way, where do I think they are, and do I think they're going to qualify? So we feel like we have a clear road moving forward to start our planning. So as Barbara alluded to in her presentation, Tennessee is very much an income cap state. And what that means is this: in 2024, if you're over the gross limit, and notice I said gross, not net, if you're over the gross limit of $2,829 in monthly income, you would need a qualified income trust. Now, I want to stop here for just a second, and I'm quite certain that Trevina will mention some things like this in her presentation shortly. But this is one of the areas that we have to make sure whenever we start dealing with our clients that our powers of attorney are up to snuff and do the things that we think they do, because a lot of times powers of attorney will specifically state that the agent under the document can actually set up revocable trust for the client. Well, technically, through the law, these qualified income trusts are irrevocable trusts. They're not revocable trusts. So sometimes banks give pushback on that whenever they see that word revocable and they potentially know these are irrevocable trusts. They don't like that. So one of the things I always stress is make certain that you take a look very early on at the power of attorney that you have for your client or potential client to make sure that if you know their income is going to be over that limit of 2829 here in 2024, that we get that power of attorney, or we have that power of attorney and make sure it has all the powers that it needs so that you could set up that, again, irrevocable trust that is a qualified income trust. Because if you don't have it, and you don't have the capacity to sign a new power of attorney, then maybe that's when a conservatorship gets involved and we have to go and ask the court to let us do that. Because kind of like with income, which we're going to get here excuse me, with the health part, and we're going to get to this in just a second. With the health part, if they don't pass that, it doesn't matter. Even if we pass the health part and we do all the correct things from an income standpoint, if we don't get our qualified income trust set up properly, then again, approval for these long-term support and service benefits for Medicaid, getting our clients on TennCare is not going to happen. So how we fix this issue is obviously the QIT, the Qualified Income Trust. Simply we call it a Miller Trust. As you can see there, I've got the case Miller versus Ibarra that this is kind of derived from. And a lot of times people think this is a spin down option. This is not a spin down option. If I had $1 for every time someone called my office and said, hey, I need a QIT to complete a spin down, a lot of times, obviously it's just that people don't know, but a QIT is not what we use as spin down options. A QIT is solely related to Medicaid. And one of the big things that I try to stress is let's say that you apply April 1st. If you don't get, let's say you pass the medical part and you get all the assets taken care of. If you don't get that qualified income trust set up until the month of June, your client is not going to qualify in the month of April when you applied. It has to be set up in the month of qualification that you desire in order to get any backdated approval, even if it takes the caseworker a while to approve the case. So I have a case right now that we had about 2 weeks and we started the qualified income trust process based on when they came in my office. The nursing facility got the doctor wouldn't come around. They had the nurse practitioner sign a letter that said, hey, it was a springing power of attorney. Sorry about that. That's where I was going with that. It was a springing power of attorney that we needed to get into effect. The nurse practitioner signed it for us. The bank wouldn't accept it, and the doctor just wouldn't come around anymore. They couldn't get a hold of the doctor. So because we didn't get that qualified income trust set up, even though based on when the client came in, we tried as quickly as we could to do everything we could over about that 2-week span. My client for that September 14th application date that I had is not going to get approved. We're going to get approved in March, because in March we were able to get the doctor to actually write a letter that the bank thought was sufficient in order to put that power of attorney in place that allowed us to set up this qualified income trust on behalf of the client. So how does the process work? There's actually 2 schools of thoughts on this, and I'm going to give you mine because I think it makes sense and it streamlines things. And then I'm going to kind of give you the other thought on that. So normally what happens is, let's say you have $1,000 left in your checking account after your client has gotten approved, and their monthly income is $3,070 a month. I'm picking this number for a very specific reason. It's over their gross income. It's over the limit that I told you about of 2829. And it also lends itself to very easy numbers for money that gets left in the QIT and personal needs allowance. So let's say that your client has $1,000 left after you've qualified, and they have $3,070 a month in income. Well, that $3,070 a month is going to come into their checking account, which if they have 1,000, that's going to take it up to 4,070. All right. Out of that 3,070 a month in income, they get to keep $50 as a personal needs allowance. So what we're going to do is we know based on how Medicaid's going to do the budget, out of that 3,070 in income that comes in, they're going to owe $3,000 to the nursing home. So out of that 3,070 that comes in, we're going to leave $50 in the checking account, and we're going to transfer 3,020 over into the qualified income trust. So once that's done, we have $1,050 in the checking account. That takes them back down below the $2,000 limit. And then we have $3,020 setting in the qualified income trust. Well, every month, what Medicaid allows is a $20 set aside out of your income in order to pay any bank fees for the account. So again, 3,070 came into the checking account. We left 50 for personal needs allowance. We transferred 3,020 over into the QIT. We're going to leave $20 for potential bank fees, and we're going to pay our expected nursing home liability, which is $3,000 a month, to the nursing home from the qualified income trust. This is such an antiquated process that's one of those things like it's just a roadblock that, again, if you don't get it set up, you're just not going to get qualified. And it's one of those things, it's just like, how does this make sense? What's the thought process behind not just letting this money come into the bank account? And again, it's to deter eligibility, unfortunately. Now, one of the other thought processes is, again, I think that this is just a little more cumbersome and difficult, as opposed to just letting the income come in, transfer what you think into the normal checking account, transfer what you think is owed to the nursing home plus $20 into the QIT, and then paying what's owed from the QIT to the nursing home. Some people take the perspective that if you get $3,070 a month that comes into your checking account, well, you only need to transfer everything above 2829 that was income over into the QIT, and then you write one check from there and then the other check from the checking account. I think my way is just cleaner. I think it just creates a better paper trail of, okay, we let the income come in, we only transferred over what was owed plus $20 to the QIT, and then we wrote a check for what was owed from the QIT to the nursing facility. And lets that $20 build up if the bank doesn't have any fees, et cetera. And that's the way that I like to do that with the qualified income trust and how we transfer money. So we can create a paper trail whenever those annual reviews come around. Now, assets, the third part of the test. Assets are either countable or exempt, as Barbara alluded to in her conversation earlier. And the link that I have there to the aged, blind, and disabled manual, I literally keep that link up on my computer at all times so that I can turn around and go to anything that I need in there, whether it be, well, let me look at this for a resource assessment. Let me look to see what's excluded, what's counted, et cetera. So if you will take that link, just know that you can find anything that you need to right there in regards to how does something work inside this, especially long-term support and services. What's an asset, what's not, how do I take care of a resource assessment, so on and so forth. So with homesteads, like Barbara said, are always exempt. Now, as John alluded to, one of the things with homesteads is they will let you keep your homestead if you're a single individual and you need care in a nursing home and you're going to apply for Medicaid, but they don't leave you any money to pay for it. So even though it's exempt, they don't leave you any money to pay for it. Remember, all your income minus $50 is going to go to realistically the nursing home, unless you have some other like Part D insurance or supplemental insurance, that kind of thing. But essentially, all your income is going to go. So you don't have anything for upkeep for the home. So even though it's always exempt, it could be a problem. So what are some of the important considerations for that? Is, again, our powers of attorney come back into play here. If a single individual goes into a nursing home and we apply for Medicaid for them and get them approved, well, at some point we may choose that we want to sell the home. And one of the things that Barbara talked about were the Medicaid compliant annuities. How we may choose to spend that money down after the home is sold is we may make a gift of part of the money and create an income stream with the rest. You have to make sure that if that homestead is sold, in this case where you have a single individual, so you don't have to worry about estate recovery potentially for that one day because the client dies owning that home on Medicaid. Does your power of attorney allow gifts beyond the yearly gift tax exclusion? Does your power of attorney allow gifts to the agent themselves? Does your power of attorney allow that's the main two that I'm thinking of right now, beyond yearly gift tax exclusion. But does your power of attorney allow gifts outside of the normal pattern? That's maybe another thing. Again, does your power of attorney, if you do choose to sell that home, let you do some of the other planning options that we might choose for this? The other thing is, again, one of the things we like to do is take a house where spouses own it and make sure that the community spouse owns it. So we want to make sure that where the joint ownership may be between what we call the institutionalized spouse in the nursing home and the community spouse that's in the that's not in the nursing home, we want to make sure we get that house over into the community spouse's name. And again, our powers of attorney let us do that. One vehicle is always exempt. I believe that Barbara alluded to that earlier as well. I have a current client that her husband went into the nursing home back in 2022, and she had totally forgotten about this and just called me the other day and said, "Gosh, I forgot we had 14 vehicles that didn't run. I sold to a junkyard, but we had them back in 2022." So I've got her going back and researching all those because only one vehicle is going to be able to be listed as exempt, the most expensive vehicle. All the others on our resource assessment in this spousal case, we're going to have to list even if they didn't run and try to get the best value that we can on them, which is likely going to be based on what they sold them to that junkyard for, because none of them ran in this case. But we still have to go back and try and recreate that. So a lot of our countable assets are our checking accounts, savings accounts, CDs, investment accounts, stocks, bonds, IRAs, 401ks. And, until, I guess it's 5 to 7 years ago, for the community spouse, the IRAs and 401ks used to be exempt as long as they met certain standards of required minimum distributions and age, et cetera, that they were taking. But now the assumption is, and just the way the laws changed, is that those are going to be countable assets as well that we have to deal with. And I've actually incorporated that into my case scenario in my case study that we're going to get to here in just a minute. Now, burial plots, businesses, pre-need funerals, all those things can actually be exempt. If you have a single individual, that single individual can have a burial plot. And if they have 3 children, they can have 3 burial plots for their children. And all those should be able to be exempt. Pre-need now a couple, again, one for each of them, and all their children could be exempt. Pre-need funerals, it needs to be itemized. It's my opinion that if the funeral costs $10,180, it's itemized. That's exactly what you paid, and we show you can pay it. And you need to make it Medicaid compliant, which is a box that gets checked or initialed whenever you're completing the purchase of that, or you go back and fill out the form. And a lot of times we see where this is put into the we it may be not be that way. So we'll put it just like it's a life insurance with cash value onto the resource assessment, but we can go back and make it exempt later, which I'll kind of show you on my overview. That says, hey, we made this exempt, and it's like we spent it. Okay, so pre-need funerals can usually be taken care of if they're not already exempt, to be made exempt by making sure that they're Medicaid compliant and that they're irrevocable, so you can't get them back. And then things like business is essential for self-support. That's kind of getting into the weeds a little bit, but people often worry about, well, I've got a business, what am I going to do? A lot of times we can get those exempted as well. So as Barbara mentioned, the 2024 limits for married individuals and single individuals. For married individuals, it's little over 154,000, and a minimum, a floor of about $30,828. And then of course for single individuals, it's always $2,000. So how do we actually file these applications when it comes time? Well, I am still a big fan of fax filing the applications to the fax number that you see on the screen there. You also have the option to mail in the application. You can actually call and verbally file an application verbally. And then, of course, there's TennCare Connect, where you go on and you create an account. You actually submit the application through the online account that you created. This allows you to check the status. This allows you to report changes, just like faxing the same things in would. The big thing is you want to create a record. I definitely don't think I'm a big advocate of, let me just call in and file this application. I want to fax file it. I want to create that TennCare Connect. Because we always want that record creation, as you see, of pros and cons there. Now, when you file the application and then thereafter, essentially the same place that you fax, where you upload information to TennCare Connect or you mail, you're also going to do the same thing with the information that you're going to provide, which is going to be the next slide, to go along with the application. So one of the things with fax filing, for example, is I like to have everything done at one time, and I try to order it the exact way that it's going to show up in the caseworker's screen for the system they use to process the case. And I want to scan it all in as one PDF, have a cover fax on it, and I want to fax it in. With TennCare Connect, you essentially upload each bank statement, and each bit of bank statements individually. You upload all the life insurance individually. And I don't necessarily like on the TennCare Connect how you name some of it, or the way that the headings that you put it under. So that's why I've still been a little bit hesitant, and I've still really used the fax filing. But one of the things you look at, you're sending all this mass document at once that I think the caseworkers are used to with fax filing, as opposed to individual document providing under TennCare Connect, that I think a lot of people like and is also a very good option. And one of the good things with TennCare Connect is you can always go on there after you filed your application and you've provided your information, and you get the letters almost instantaneously when they get produced by TennCare. Hey, we need more information, we need this, we need that, et cetera, et cetera. So there are also some HIPAA forms that TennCare, if you go and look on any of their applications, they say, hey, these are our forms, we'd like for you to provide these. I'm always an advocate of providing those. So here are a list of some of the standard verifications. I'm not going to spend a lot of time on this slide, but one of the things I want to point out on it, because I've only got about 10 minutes left, one of the things I want to point out on it are, I consider doing a resource assessment that I'll show you guys here in a minute, a standard verification. Now, TennCare is going to do their own, but help them along. The way that their TennCare, the way that their resource assessments come out are very odd in how it splits this and splits that. And I don't think it always splits it the way it should be. So do one, send it on to them and say, here's what we think it should be. And a lot of times, if you build really good credibility, I think they use that a lot because they know, hey, this is going to be done the right way. When I look at the numbers, it matches here. This is just a little easier to read. Do an overview for single individual or spousal cases. Say, hey, here's where things were. Here's everything we did, and here's where things are now. Here's why this person should be eligible. And this is, again, the standard things that are needed. Sometimes you get those letters that say, hey, we need life insurance, we need this, we need that. Well, the person doesn't have it. They don't have that. So you can just reply back and say, hey, they don't have any of this. We provided everything that you needed, but this is a general list of everything that you want to provide to your clients. And one of the big things I'll focus on before I move on is whenever you provide financial statements for bank accounts, investment accounts, et cetera, provide the full statement. If there's 8 pages to that bank statement, provide the entire statement, not just a couple pages from it. I think caseworkers really look for that, and that makes a difference. Now, there are obviously early planning options and what I call maybe later planning options. I think one of the things that John referred to that is, I know Tim has definitely used this term before, crisis planning compared to pre-crisis planning, but with real property, that's one of the biggest things we see. The same thing falls under money as well. But with real property, giving your house to your kids is just usually not the best option by quitclaim deed. We're going to create civil liability issues. We're going to create stepped up basis issues, tax things. So that's why a lot of times we use those Medicaid asset protection trusts. We use those VA asset protection trusts like Barbara talked about, that you can make intentionally defective grantor trusts to preserve that stepped up basis, to get creditor protection, to essentially do everything that's needed, but not create some of the bad things that simply come along with simply just doing a quitclaim deed of your property. And if you can make it that 5-year and 3-year, as required, as Barbara said, and I think as John said too, let's just make sure we're going to make it that 3 or 5 years, or have a plan in case you don't. That's a really good way to do some early planning for both your real property and your money with those asset protection trusts, so that you don't get necessarily into a crisis situation. But if we do get to a crisis situation, some of the things that we look for specifically to complete spin downs once we've gotten ready to make application or not ready to make application is there a mortgage on the home that once we've done the resource assessment, we know how much needs to be spent? Maybe we pay off that mortgage. Maybe we do some home upgrades. Maybe we purchase a new home. There's the child caregiver exception that Barbara talked about. Maybe we can transfer that house to the child that provided care for 2 years for their parent. Purchase a new vehicle, Medicaid compliant annuities. Again, this is where age of the individual comes in, because in spousal cases, they have to be actuarially sound. You can't do a 2-year annuity for a 99-year-old that has a half-year life expectancy. So age is very important in that. Sometimes when we do them for spouses, you're going to lose a little bit of the allocation if the spouse outside of the nursing home has a low income they might have gotten from the spouse in the nursing facility. But a lot of times it still works out based on the amount they save by what they don't have to pay privately to the nursing home. And the other timing part that I'll add in that is, I am an advocate of no application in, resource assessment complete, annuity set up, first payment received, and then apply for Medicaid. I think there's some leeway that, if you go ahead and apply, and you get the annuity set up. But I think just by my interpretation of it, I feel safer having the annuity set up, the first payment in, and then you turn around and actually file the application. Again, pre-need funerals are something we often do. And then there's certain considerations like having a disabled child that may be on SSDI. And we're going to get into that real quick as we look at my case study here. So in this case study, Hunter and Karen, you can see and you can read it here, met in college. They have 3 children. Hunter unfortunately developed Alzheimer's, but also their child Janice was disabled and is receiving SSDI benefits. Now, I picked some very high numbers here. I don't always see clients like this walk in. I picked the very high numbers so you could kind of see and maybe remember this example on how things work. So here, Hunter and Karen have a car. They have about 250,000 in cash assets. They have IRAs worth 200,000 and 500,000, and they both have very good income. Hunter's monthly income is $3,200 a month. Karen's monthly income is $4,200 a month plus a pension. So what are some of the important considerations? They're married, so we're going to have different rules that apply to them. They're both over the age of 65. They're not veterans. They both have very good powers of attorney. I skipped over that, but they both have very good powers of attorney. Their daughter Janice is on SSDI. Hunter has I think I that meant to say 4,200 a month on the other thing. It said 3,200 in income. Karen's monthly income is very high, 6,200 a month. They're going to have one home that's exempt, one vehicle that's exempt, but then their other countable assets are well over 500,000. So let me, if I can, switch, and I think this should be coming up now. This is the resource assessment that I would do for them. So you can see I've listed their home, say it's $700,000. It's exempt. Their Land Rover is exempt. It's the only vehicle that they own. And then between their checking, savings, and investments, 40,000, 50,000 in their checking, 100,000 in their savings and investment, and then you see the values of their IRAs. One of the things I want to point out is right here is one of the things that TennCare does that I've come to realize is they will out of that subtract out both the applicant's income and the non-applicant's income to say, okay, well, even though you had 50,000 in that account, we're going to subtract out their income, and the remaining amount is what we're actually going to use as equity value. And the only thing that I think this does is it hedges yourself to say, okay, it's probably the 50,000, but if I subtract out the income and I make it a little bit lower, it's not going to hurt me at all. So this is the resource assessment that I use. Now here in this case, Hunter went into the nursing home February 1 of 2023. Now, one of the things that I did here is this is the 2024 limits, but one of the things you have to remember when you do a resource assessment that you have to comply with for married spousal cases is you have to go by whatever the resource limits were whenever they went into the nursing facility. So in 2023, when Hunter went in, we'd actually have to go by the maximum of $148,620, not the $154. Very, very important to remember there. So back over to the slides real quick, and we're almost done here. I know I'm running out of time. One of the things we want to do for this case is we immediately want to complete that resource assessment like I've just showed you there. Here, we may not want to file the choices application right away because one of our likely options we'll go to in the next screen is we may want to set up an annuity for Karen. And again, I like to get that set up before we turn around and apply. Of course, we make sure pre-admission evaluation is in. From the date you file your application, you have 90 days to provide all the information that's needed. I still try to work off a 45-day time frame. Technically, you have 90 days to provide all the information to TennCare. Now, remember, if you apply in April, you need to be spent down in April, but you may have until June to provide all the information, but you still have to be spent down, just like where the QIT has to be set up in the month of qualification. If you apply in April, your spend down has to be complete in April. So here's what we might consider in Hunter and Karen's situation is we know Hunter's going to need a QIT, so let's make sure our power of attorney is in good place. His income's more than that $2,800 a month. They have the options of paying privately. They have the options of, because their child is on SSDI, again, SSDI is means tested, SSDI is not means tested, SSI is, they could actually transfer money to their disabled child as part of the qualification process. And that child could hold that money for them and it wouldn't be disqualifying. We could also take a look at setting up a Medicaid compliant annuity for Karen. We know her income is way up there. So setting that up for her isn't going to be an issue. Here in this slide is to show where and why and how transferring to a disabled child is allowed under the age, blind, and disabled manual that I talked about that you can take a look on this slide. And then also, one of the things that we might look to do, you see at the bottom of the screen here, is that 1035 exchange. So because Karen's IRA, and I kind of skipped over that, is in an annuity, we might be able to do what's called a 1035 exchange and put that into a Medicaid compliant annuity as part of our process. So this spend down process could have two ideas. We could surrender Hunter's IRA and take the assets we need to, to get them under about 140,000 and put that into Janice's name to hold for them. And then we take Karen's IRA and we make it Medicaid compliant with that 1035 exchange. And what I want to show you is at the end, here's what I would send to the caseworker to let them know here's what we've done. And this is a typo again. I hate that. I'm so sorry. Hunter went in February 1, 2023. The spend down for this case was achieved by personal needs, nursing home private pay, gifting to a disabled child, a Medicaid compliant single premium immediate annuity. I went back and listed the total amounts of February 1, 2023, what their assets were. Here's what the limit was in 2023 for the community spouse. Now, here's where their assets sit as of April 30th when we applied on April 1. Exempt home, exempt Land Rover. We left 20,000 in the checking. We left 20,000 in the savings. We left 100,000 in the investment account. Hunter's IRA was closed. Maybe we gifted some of that to Janice. Maybe we added it and created a second annuity for Karen. We moved Karen's IRA that was already an annuity over to that Medicaid compliant annuity for her. So all we have left, caseworker, is $140,000, and we actually could have kept $150,620. And then I also go on down here to list. And I provide verifications for this. Here's exactly how much we paid the nursing home. Here's how much we may have gifted to Janice. Here's how much we put into the Medicaid compliant SPIA. And also, always list the attorney fees that we paid on there. And the number that ends up down here should show, when you subtract it from the 940,000 in this case that we had, when you subtract what was spent down here, it should show this is why we only have about 140,000 left. So I think I've come to the end of my time by a few minutes there. Probably could have gone on a little bit more, but hopefully that was a good summation of all the good stuff Barbara said, all the good stuff John said, all the good stuff Pam said, with some real life examples, and you all are able to go back and look at those slides. And I think the resource assessment overview should have been sent as exhibit. So Barbara, were there any questions that I missed at all?
I'm looking, and I don't think so. Great job, Bryson. Nobody knows it better than you.
Well, I really appreciate it. Thank you. Thank you for letting me do that, Barbara.